Bruce? Bruce? What, where are you?
Hello.
I hear you now.
Well,
I can hear you. Can you hear me?
yes, I can hear you. Let me try and get on. I think this is weird. Hold on. It's trying to get me in full.
I see the logo.
Let me just try again.
There you are.
I was weird. I came on, I guess. I don't know why I'm getting a reverberation.
It's probably because you have is this a phone that you're on too?
No, let me click off the other one.
Yeah, no, it should be okay.
How's that? All right. Can you hear me okay?
Yes.
All right. Well, I guess my thought is I'll just start at like the opening slide and then go through it as if, you know, um, we had a live audience.
I know.
So
Sounds good.
why don't I go ahead and bring that first opening slide up and then you can.
It's recording, so we're good.
So, morning, everyone. Here we are with our annual New Laws Webinar, letting you know what things we need to be aware of and how to prepare for January 1, 2026, based on what the legislature did to us for the last year. So, you all know me as the presenter, and here's our overview. Again, unless otherwise noted, new laws that we will list take effect January 1, 2026. And the bill link that is there will show you how the bill changes current law. If it amends current law, what you'll see is current laws in black and blue will be the changes. So it's a lot easier to see what changed. And of course, some laws create new sections in one of our California codes. So um, it'll all be blue, but it's a lot easier to read that way. And there's usually about 1,000 bills that pass the legislature every year and get signed. We are only looking at bills directly affecting our HCC members, contractors, and suppliers, things that we either need to be aware of or prepare for or make some adjustments as 2026 comes upon us. And we'll look at laws, new laws by their categories. We'll look at 27 different laws that we need to be aware of and focus on. And just the first part there, overview of what we did in 2025. Our contract lobbyist, RJ Cervantes, worked with other coalitions like led by Cal Chamber. A lot of bad bills were defeated. We'll look at some bills. Many of them were dramatically amended. We'll list a lot of our opposed bills, and you'll see that some were amended multiple times. And that's part of the challenge anyone has in this legislature, dominated by progressive Democrats. They are not liking to do the old traditional way of doing legislation where you sit around a table, figure out what wants to be accomplished, and everybody collaborates and or compromises to get to a consensus position. They float a draconian bill and you say, here's all what's wrong with it. And they float a few changes, not nearly enough. And then you say, that isn't good enough. And here's what's still wrong. And they just keep doing this arm's length thing until finally they peel off enough people so they can get the bill passed. Many are still passed over our opposition, but they are significantly watered down. So you'll see that amongst several of the bills. And next year is going to be a very significant year for a couple of reasons. One is, as we know, Governor Newsom likely wants to run for president in 2028. He has promised to take care of housing in California, promised when he was first elected he'd build 2.5 million housing units in 5 years, and the actual number was 420,000 something. So he is way behind on his promises on housing. He will probably want to do something on housing, but as we know, there's a lot of competing interests, environmentalists, labor groups, and so forth. So we will be directly in the fight because obviously there are types of bills that could be passed that could be really detrimental to our members. And some bills are just feel-good bills. This year, the legislature passed 37 bills on housing. None of them will move the needle. It's just taking little teeny bits and trying to do something instead of addressing the real problems. Next year also, we will be pushing back on, as was just announced, California has a projected $18 billion budget deficit. And instead of cutting expenses, of course, California says, well, how can we raise revenue to meet our budget deficit? So we're going to be pushing back on a lot of those. And antitrust issues will also be front and center in the legislature in 2026. And some may think, well, we're immune. We're not big enough to be antitrust related issues, but unfortunately we are. There are progressives in California who really want to hit the antitrust issue on multiple levels, including any business in any area or region of the state that has any kind of dominance, of market share. And for them, dominance is not what it used, we used to call it over 50%. You might say you're dominant in a market. They're talking about if you're 30% in the market. Well, some builders could be just considered that. Some trade contractors, some of our members in a particular area could be considered, a significant or dominant player. So we are going to pursue making sure we don't get caught up in antitrust legislation. So let's look at our 27 bills. Well, just real quick, yes, we reviewed approximately 300 bills, 175. You can see how many we supported, how many became law, and a few continue into 2026, and one was vetoed that we opposed, and two were vetoed that we supported. What helped us was the budget deficit. Looking at 2026, the governor did veto quite a few bills, and or sent a message he would veto a bill, so a lot of people stalled out bills going to 2026. All right, let's jump into the 27 bills we need to have an awareness of. Ash Kalra, who normally does bills we don't like, did this one again, amended 7 times. No real negotiation over the bill, just arm's length. And it affects employment contracts entered into, as we see next year. So if you are someone who does employment contracts and with some people, you need to be aware of this. Hopefully, it won't affect our members significantly, but evidently, quite a few employers do an employment contract where they agree to provide some training or education for the employee, and then the employee either gets the education or most of it and terminates the contract, and the employer tries to say, well, you need to repay me for the value of what I've loaned you or the training I provided for you. And this disallows anything like that. So you'll just need to make sure if you use employment contracts for new ones, January 1, 2026 and after, they need to comport with this provision. AB 774, this bill makes minor supposed clarity changes to garnishment of wages. It's a long bill. You can look to sections 6 and 7. We should just be sure our procedures fit these specific changes, timelines, some other things that when we do have to garnish wages, which we would prefer not to do, but often are forced to, that we're in sync with the current changes taking effect January 1st. This bill by Mr. Gabriel, amended 2 times. We don't like it. And part of the problem we have, as we've talked about in the past, the Labor Commissioner's Office has been led by someone who's well-intentioned, but not a good administrator. And while they have been fully funded for all positions, they are about 20% of total staffing, meaning they have an 80% staffing deficit. So it's easy for people to say the labor commissioner is not able to enforce wage and hour laws. That's why they've been promoting having local authorities do it. And now this bill does allow the California Attorney General to bring a civil action against a contractor for failure to pay full wages. This is where people who are friendly with the Attorney General get this bill passed. And so hopefully it wouldn't be an issue for us. But, this is where someone like a labor union or a local party who doesn't like us and is friends with the Attorney General could say, hey, go enforce against this particular contractor. The Attorney General normally wants big statewide issues. This gives them that sliver of opening for that. And, the problem is if we got on the wrong side, the Attorney General could ask a court to order CSLB to suspend or revoke, deny a renewal of the license. So hopefully it rarely happens to us, but we need to be aware. Again, as we always say, we need to be taking care of wage and wage disputes so no one can take us to an enforcement authority. hopefully, or it's on a reasonable appeal basis. But if we find the Attorney General ever pursuing us for wage issues, we need to take it seriously and respond fully. Mr. Calver, again, this is if you are a signatory contractor now in 2026, your business agent will be able to establish a confidentiality of communication similar to an attorney-client privilege communication. And so we need to be aware of their ability. And hopefully most of us have a good, reasonable relationship with business agents, but understand they will have some abilities to do some things that we will not be able to find out very readily as they do. SB 261, this is again the Labor Commissioner candid for. And the other thing the Labor Commissioner's office does poorly is even if they get a judgment, collect it and get employees paid. So again, amended 5 times. This bill will triple the penalty for an unsatisfied judgment, not a pursuit of a claim, but after a judgment has been rendered against us. So we need to make sure whenever we resolve a case, and if it's considered a judgment, we pay it cleanly and document that so nobody can come back after the fact and go after us, because this is pretty draconian in that situation. SB 294, this is a bill that started out or should have been not that big a deal. Workplace Know Your Rights Act. So the first part of it is the Labor Commissioner will develop a template notice of employee rights by January 1, and then by on or before, between then and February 1, 2026, we need to provide this notice on a standalone basis, meaning not posted, a clarity of we communicated directly with that employee either by an email that's confirmed, communicates with them, etc. You'll see in the bill the different ways you can do that. It will be really important because if we have any kind of PAGA claim or other claim, the first thing they're going to ask is, did the employee get their Know Your Rights Act notice? And of course, the employee is going to say, I don't think so. And it'll be up to us to document that we got it in their hands by February 1. And each year it will be updated with any changes to the laws. So we need to do it every year. It's a second part of the bill that's really concerning because the penalties are significant. And you can see it's intended for responding to ICE raids on work sites. So this notice that we are going to provide to employees will have, and they'll probably bold it or make it, stand out, that an employee has the right to designate a contact, that if the employee were arrested or detained on our work site, that we would need to contact that person. So we're going to, again, need to document that employees got the notice, that informed them of their rights, and that we have a clear path that if an employee does designate a contact, we kept that information and we attempted to contact that person if that person that employee who designated that winds up being arrested or detained on our work site. So again, we need to take steps and be able to document our position. As you can see, the penalties are significant for this. And again, enforcement can be by the Labor Commissioner's office or a public prosecutor who can collect attorney's fees. And of course, we know oftentimes in those types of situations, the fees can magically get to be more than the penalties themselves. Senator DeRosa, SB 513, she also usually puts bills out there that we don't like. And this is there's a little complexity to this bill, but it was intended so you get a sense of why you would do something like this. It was intended for as California's backed off fossil fuels and employees who worked in refineries wind up suddenly looking for work after working for a refinery for 20 years. And those employees have said, I don't have records of my training and certification. So when I go out in the marketplace, I can't show what all I earned over the last 20 years. So, and instead of focusing just on refinery employers, this bill is focused on all employers who maintain records. Keyword there is maintain of employees' education and training, need to provide copies to inspect those records. So we know for Cal OSHA, potential citations and penalties, we need to have documented training records that we train the employees for how to safely do or operate whatever we needed to. So, we clearly need to maintain training documents. But education documents are a different potential category. And if we choose not to maintain education documents unrelated to safety training, then we are not by this bill required to produce copies of those documents. So this is a tricky situation. You will want to consult with your labor attorney, I think, and make a clear demarcation between what's an education record, what's a training record, and especially safety training, and say, how do we navigate this? Because otherwise, any new training and education we provide, or technically the way this is worded, an employee can ask for any documents we have maintained. So we're kind of stuck between, do we want to maintain records to prove things, or do we want to not maintain records to have to document them? And what if we don't have the particular record for a particular employee? Are we in trouble for that? So something to walk through with our labor counsel and say, how do we deal with this? If you SB 597 Cortese, again, this is one of those amended 4 times. And as we know, the genesis of this, or the background of this, is labor unions wanted to be able to pursue owners or general contractors or even subcontractors who had second tier contractors when a union when a union contractor was working for one of those people, if they were behind on benefit payments. One of the union groups, their benefit costs are $29 an hour besides wages. So you can have a signatory contractor who has paid employees in full, but is behind on benefit payments. And of course, unions need to pay for benefits that are owed by the CBA. So this provision, but it also included if the subcontractor didn't pay wages. So it would apply to those non-signatory contractors regarding wages, et cetera. We're not aware it's been a real problem because our members pay wages, or handle any wage disputes themselves. They don't ever involve a general contractor, builder, developer. But when unions have tried to make a claim for the health benefits against the contractor who's holding progress payments of that subcontractor, the courts in California have said, we think the federal regulations, Employee Retirement Income Security Act, preempts it. So this is an attempt by theirs, and they hope that they've fixed it now so that they can make a claim for benefits unpaid to the union trust, that they can make a claim to the owner, developer, general contractor against a subcontractor and divert funds. So if you're a signatory contractor, hopefully you're making sure your health benefits are in retirement or in full payment to the union trust funds, and it won't be a problem. So we'll see what happens. All right, SB 617. It's rare that our members have to do a mass layoff. Normally, we're not so much of a fixed plant and having a certain percentage of employees being laid off. But if we ever do, this changes those requirements to add a section that informs employees what assistance will be available. Do we, as the employer, provide some assistance? Do they need to go to the state and who they would need to go to or federally? Um, so if you ever do have to give one of those uh, WARN Act notices, make sure you follow these new regulations. Again, Senator Durazo, and again, they were focused on trying to help the party who operates a vehicle for a construction firm, but who's declared an independent contractor by the construction firm, but they're not a PUC licensed trucking company. And where, are they in limbo over are they an independent contractor or not? Obviously, the Dynamics decision in AB5 and even preceding law for construction said those were employees unless they operated for a licensed subcontractor or were an employee of a licensed trucking firm. And now they've clarified that. And we wish they had stopped there. And unfortunately, as usual, they didn't. So this applies to all contractors and who pay employees who utilize their personal vehicle in the discharge of their duties. And, most of us do this. We issue a 1099, separate check, 1099 on that, and then wages. We'll just need to make sure that we are okay with this. I imagine most of us are, but we need to run this by our labor law attorney and just say, look at our procedures and make sure we're doing this right. And what they're focused on again are some of the larger construction firms that had all these independent supposed contractors, and they actually provide an amnesty program. If you think you might have misclassified people in the past, you could consider the amnesty program. It's pretty tight and will be hard to do, but at least it's an avenue for those who have misclassified their drivers in the past. This bill is just a pain. SB 464, it's called the Latina Pay Equity Act, is what they're trying to do. So as we know, the federal government requires somebody with 100 or more employees to file an EEO-1 annually. California said, well, we want more information, so you have to file your own if you're that size or greater. And so they're changing the form effective 2027. So in 2026, we'll fill out the form. It's usually done in the spring. They have different date deadlines. They'll do it. So the information we provide in 2026 will be based on 2025 information, and that won't change. But when we fill it out in 2027, things will change regarding new job categories. And also, and I guess, as we go forward in 2026, the bill requires any demographic information, ethnicity, national origin, gender, etc., to be collected and stored separately from employees' personnel records. And it's like, well, employees' pay records include usually gender and things like that. So this is where something that may have included employees' names alongside that needs to be kept separately. So it's, again, a pain. You'll just need to walk through with your labor counsel and say, are we following this directly? And then what we need to do if we list people in those job categories, what we probably want to do is starting in January 1 of 2026, change into the new categories. You still have your management and clerical, et cetera, but where in up through the end of this year, there are categories, craft workers, laborers, and helpers. Those categories will disappear, and we have new categories of construction and extraction occupations, separate one for installation, maintenance, and repair, another separate one for transportation and material moving occupations. So I would think we'd want to incorporate those changes as of the start of the year. So when we fill out our form in 2027, um, then we would have these new categories. So um, again, just another pain, and does anybody really look at this and what does it do for them? But there we go. SB 642 by Limon, again, amended 4 times. It supposedly gave us something. As we know, we're supposed to show pay scales in any job advertisements, etc. And some employers will use a very wide range. Um, and but some employers try and do a reasonable range, but some employees don't fit usually the advertised range. So it says if we have done a good faith estimate and the employee winds up a little below or above that, we have some defense on that part of the issue, but it also, and a much bigger issue, it increases the compensation period for pay discrimination claims to 6 years from 3. So, boy, if we have a pay equity issue, they now can go back 6 years on it. So this is why, we think it's a wise thing with all the different issues with labor laws, that we have an annual audit by our labor council to say, hey, make sure we're doing all these things right, because we especially want to make sure we get our pay equity right as we go forward. Okay, and this is actually a good bill under workers' compensation. As you know, there's a qualified medical evaluator the state has a panel of them, and that's who you send your disputes to, and they analyze medical information and then issue a ruling, usually after an examination of the employee, et cetera. And a couple of years ago, the QMEs got um, some legislative leverage and really increased their ability to charge for doing these evaluations and writing their reports. And now they're just extremely expensive to do, which puts pressure on us to settle a claim, dispute, even when we think, we're on the right side of it, because by the time you would go through the QME process, our defense attorney might say, it's going to cost way more than settlement to get there. This is a good bill by Mr. Wallace. We appreciate it. It will improve the procedures and the oversight of the process. And they have to have those procedures in place no later than January 1, 2027, could be done in 2026 sometime. And so hopefully this scales back those issues where we're not sitting there having a defense counsel saying, well, we better settle this because a QME will be too expensive. If we wind up going that route, that we may even in 2026 wind up asking our defense counsel, hey, could we delay settlement on a claim a little bit until these procedures take place? We don't know fully how effective they'll be, but certainly it's a step in the right direction. So we need to be aware of this, and could potentially help us out even in 2026 if they move on it. And this is, a good bill. Valencia trying to close more loopholes on kickback schemes. As we know, there's lots of those in workers' compensation. And, we may say, well, I'm usually not directly aware of that. One of the things, and especially as we talk with our claims adjusters, the Department of Insurance is incentivized by workers' comp surcharges we pay as employers to investigate workers' comp fraud. and that includes provider fraud, which this is focused on. And they have a place to send in complaints, and we may say, hey, I don't have any evidence or documentation. I heard something. An employee said they heard this provider, has to pay a kickback to the referral attorney or vice versa. Um, and all we have is a suspicion. We can send that in to the Department of Insurance or have our claims adjuster or our insurer's specialized investigations unit, because what the Department of Insurance says is if one person notifies them and there's not much evidence, they probably won't do much. But if 10 people send them suspicions of a kickback scheme, then it raises the level and they're incentivized again to look into this and try and pursue it. So um, be aware whenever we're sense or hear something that might be amiss between a medical provider, a provider of medical equipment or so forth involving kickbacks, don't hesitate to send it to the Department of Insurance. Okay, and this is again a good thing for us. We unfortunately have to compete with employers who do unfair competition. And one of the ways people do it in construction is they have a corporation which is licensed and has workers' compensation. That corporation takes a subcontract and then subs the labor out to usually a sole proprietor entity that one of the corporate owners owns that has no workers' compensation. And they pay cash and do all those kind of things. So what this does, we pay as employers, part of our workers' comp surcharge pays a total of $50 million a year into the Uninsured Employers Benefits Trust Fund, where an employee who is injured on the job and their employer turns out not to have workers' compensation, the employee makes their claim to this trust fund and gets paid as if there was a workers' comp carrier adjuster there to pay them. That trust fund is allowed to go after the owner of the company or business that did not carry workers' compensation. And this closes a loophole from people who try to hide assets when they're being pursued by the trust fund. So it's a good bill for us. We appreciate that. And this is the one housing bill we'll talk about. Amended 13 times. Amazing. And this is a feel-good bill, we believe. Again, they get the environmentalists on board by saying we're going to force more housing near transit-oriented developments, like within a proximity to a train station or something like that. It requires prevailing wages, and if the project goes over 85 feet in height, it requires the skilled and trained workforce requirements of a certain percentage of your workers being graduates of an apprenticeship program. So this is why normally these things don't pencil out. Um, but it made somebody feel good. Senator Wiener, who appears to be wanting to take over Nancy Pelosi's federal seat in Congress, he tries, but this is, he caves in enough people to get a bill passed that they hope might do something. The thing we need to be careful of is some builders or developers will try and pursue a project that does pencil out. And of course, they're doing it over the opposition of either local NIMBYs or local environmentalists or just the local jurisdiction, city or county. And so we need to be prepared if we're bidding on a project subject to that we're very careful on our price guarantees. And we also need to be careful of, because sometimes, a builder developer will just start the project trying to force it. And then the parties involved get a court to shut it down. And what happens if our work is halfway underway and the project and we're told to come back 9 months later when it gets resolved. So we need to make sure our proposals on these projects are, protect us from all the litigation that could happen as these things go. This is a good bill, Cal OSHA bill. Michelle Rodriguez gives this bill. Basically, it says if an employee of ours administers Narcan to someone who is in a coma on a job site or near, then it gives liability protection as long as we're not a medical practitioner. Cal OSHA is attempting to try and force employers to have Narcan in our first aid kits. That's at least 2 years away from probably ever happening if it does. But some employers, want to consider providing Narcan because who knows who may show up, and we have some serious drug issues going on out there. So if you do, you can know that this bill will give some reasonable liability protection if one of our employees tries to help someone out administering that. The Cal OSHA bill, I don't imagine it will apply to our members. Cal OSHA has been very engaged on the cutting of artificial stone. Artificial stone has a hugely intense silica content versus natural stone. And so Cal OSHA has put a bunch of regulations in place. This is kind of a pile on top of that piece of legislation. It focuses on if you run a shop where artificial stone is being cut, prepared to go to a job site or something. So if it does apply to you, you probably are already aware of what Cal OSHA is doing. So this just adds more enforcement and penalties for doing it wrongly, dry cutting or things like that. Contractor State License Board, some of our members will do the occasional one-off through a home improvement contract, which are regulated by the Contractor State License Board. Some of our members even do, some service contracts, warranty contracts directly with homeowners through these. We need to be aware there are cancellation notification requirements changing effective 1/1/2026. So if you use those contracts, make sure they, agree with the changes, because obviously we can get in trouble if we don't give a homeowner the right kind of notice that they can cancel a contract and under what time frames. And then again, a good bill by Mr. Grayson does two things. The type we talked about, the unfair competition, where a sole owner licensed contractor, and again, that's usually someone where a licensed subcontractor is farmed out the labor to. They claim an exemption for workers' compensation coverage. There's greater penalties by CSLB against that contractor. And also, sometimes we can get involved in a CSLB complaint issue and where we made a mistake, and CSLB may issue a citation. It gives good faith factors to reduce those penalties. This is something to help CSLB out, because as we talked about, under the home improvement contracts, which is, a contract doing work, remodel or build for a single homeowner, the homeowner will complain to CSLB, and the party that issued the home improvement contract will say, well, it was not my fault. It's a subcontractor I hired. So this says under HICs going forward, if you use a subcontractor, you have to show it who it is, and CSLB can use their administrative discipline for anyone performing work under the HIC, whether they were the direct contractor or a subcontractor. Again, a good bill against unfair competition, increasing penalties for unlicensed contracting, where the licensed contractor subs out the labor to an unlicensed entity, sometimes we still see that. Public works projects, this just gives a little clarity to those who request certified payroll records through awarding bodies. As we know, many of the larger awarding bodies put projects on the state electronic website. So this is normally involving smaller awarding bodies and parties that want to request certified payroll records. So we need to make sure if we get a request for certified payroll records through the awarding body that we respond their timeframes. We have to do that by. And there's an annualization issue for public works per diem wages. Unfortunately, they said there is a problem to fix, but these changes don't fix the problem. It's a challenge. So if you do public works, you will need to review how you do annualization to make sure you fit with the new changes until they eventually, hopefully, actually fix the problem. This is a concerning bill. And again, next year, there will be a lot of legislation pushing antitrust issues. This bill was amended 7 times. And the concern is parties to complain on antitrust, they can say they're required to have factual allegations, but now they only need to be plausible, meaning they don't have to provide evidence. It's just if there were evidence, this could be true. So we're concerned about that. And so we need to make sure if anybody makes a complaint about antitrust issues towards us, we need to take it seriously because this will be ramping up as an issue. And the second part, I'm not sure our members are involved in this, but certainly there are people that use pricing algorithms to differing competitors use the same pricing algorithm to set prices, and that can look like restraining trade or commerce. So we're supposed to use our own. I don't imagine that'll apply to many of us, but we need to be careful if we're using anyone else's algorithms to price what we do. And this will be probably the first and last time Mr. Kalra floats a bill we like, but it is helpful to us. As we've talked about a little through our trade memos, there are litigation funders out there who provide loans, generally, sometimes to attorneys, plaintiff attorney themselves, but usually to plaintiffs when their attorney says, hey, we can get you $1 million payday, but it'll take 5 years through the courts. And the party says, I can't wait that long. I'll run out of money. So we need to settle now. And this allows that plaintiff attorney to say, well, here's someone who will loan you money to get you through that 5 years. And the problem is those litigation funders, it's the Wild West out there. Their interest rates are exorbitant. It's a real problem. There was one case recently talking with a claims adjuster where the insurer was willing to settle for $1 million. And by the time that was done, the plaintiff said, well, I owe my plaintiff attorney a third of the money. And the litigation funder is now running up $600,000 in interest, excuse me, and principal on the loan. So I'd get $50,000 out of $1 million. So no, I'm not going to settle. So this bill will, starting in 2026, make some changes, helpful changes to start limiting this. And we normally see these kind of cases in personal injury cases, auto liability especially. So we hope this starts to turn that around. It is something we need to be aware of. If our defense counsel says, hey, there's litigation funding supporting the plaintiff in this project, sometimes we want to say we better settle out now because this plaintiff could be abused by the litigation funder, and they'll be unwilling to settle when we need them to settle. In this bill, good bill by Mr. Cortese, uh, limits maximum retentions on private projects to 5%, and it's got a lot of double negative wording in there. If the project is 4 stories or less and is not mixed use, then you don't get the 5%. So we hope eventually we can expand to that, but some of us do projects that are, mixed use and exceed 4 stories. And this will limit the retention to 5% if you have a new contract entered into after January 1, 2026. So we need to be careful because some of us are on master contracts with developers or builders, and if this project is an addendum of that master contract, then it likely would not qualify for the 5% protection or reduction of retention. So we need to try and make sure those are on brand new contracts entered on or into, or even if we try and negotiate that we get 5%, if it's an extension of a current contract. And this is a really good bill. Again, as we know, with some owners, general contractors, builders, change orders can be a major problem. Trying to get them documented, trying to get paid for extra work. We've even seen some owners and general contractors kind of go into cahoots on, tell the subcontractor it's a change order, but it winds up the change order between the two of them was defective, so nobody gets paid for the change order. It's a challenge. So this is a good bill. Senator Ochoa Bogue out of Yucaipa, her family's contractors, so it's good for her to bring this bill. It does, again, apply to new contracts. So make sure that we're trying to get either an agreement that we get these new changes or that we get a brand new contract. You'll see there's the series of procedures we have to go through when we're doing change orders. But if we follow those, this gives us some real help in enforcing getting paid for those change orders. So that is our overview of new laws for 2025. And thanks everybody for attending. If you have any questions, just give me an email or a call and we'll go ahead and respond. And hopefully 2026 will have a good year, but we need to walk through, make sure we're in compliance with these changes to laws that we just went through. Thanks, everybody. Have a good day.